So when approaching a business rescue, most of the time the root cause of the distress is mismanagement. When replacing a board, sometimes the BRP needs to resort to a legal process and declare a director delinquent. We are catching up with Jessica Osmond, who is an associate at Klipdecker Hofmeyr, to discuss the process behind this. Jessica, let's start at the beginning. What does it mean when a director is declared delinquent?
Thanks, Jonathan. So yeah, I think the beginning is a good place to start. And for purposes of this discussion, I think it's very good to have an understanding of exactly what it means to be declared delinquent, like as a director. The term of late has been thrown around in the media quite often, but I think the average man on the street doesn't actually know what exactly it entails and the actual effects of such an order. And so in understanding the term better, I think it's important for one to have consideration for Section 1625 of the Companies Act, which actually specifically provides for this declaration of a delinquent director in various circumstances. Obviously, these circumstances are provided for in the Act, and we've had case law, recent case law kind of grappling with what those circumstances are. And I mean, I'll get into that a little later, but I suppose it's in terms of meeting that threshold, establishing those circumstances, and bringing the necessary order in accordance with the Act. And the effect of such an order, I think, is far more severe than I think we're very used to the removal of directors from a company or from a board of directors, but deeming or declaring somebody a delinquent director is a far more severe sanction. And so this ultimately actually disqualifies someone from then being able to act as a director of a company. And the sanction may subsist unconditionally for a lifetime, or even so the minimum sanction is also quite severe in that it's a minimum of 7 years. And so the duration and the duration of the sanction and the conditions linked to that may vary, and that's to the court's discretion. But that's decided on a case by case basis. But the court, you would definitely need to prove those circumstances, and the court would have to make that decision.
You mentioned, a specific section within the Companies Act. So what needs to take place in order for a director to be declared delinquent? What kind of mismanagement needs to occur? Can you provide some examples? Is there a specific test?
So first thing to note, which is interesting in the Act, and as I said, the Act is quite good at it, it sets it out, but what is difficult is then it's one thing on paper, it's another thing in real life. And so starting at the beginning, starting at the wording of the Act, Section 1625, it imposes a peremptory obligation actually on the courts to declare a director delinquent in certain circumstances. And so by judging the wording of the section, it's actually interesting that if the grounds of delinquency are established in terms of the Act, the court actually must then grant this order, and it has no discretion as to whether or not it should or shouldn't. Yes, it has discretion in terms of the sanction to impose and any other conditions that will go along with that sanction. But the court is actually obliged to make such an order. And so specifically Section 1625, and I'll paraphrase, but it includes the circumstances, which I'll list, but it's not limited to that, but instances where a director has grossly abused his or her position as a director, or where he or she has taken personal advantage of information, privy to him or her by virtue of their position as a director, where they've used that information and taken an opportunity to gain an advantage for another person or another company for whose board they do not serve, or knowingly causing harm to the company or subsidiary of the company. You've also got the consideration where, in the instance where a director intentionally or by gross negligence inflicts harm upon the company or a subsidiary thereof, or simply acts in a manner that amounts to gross negligence, willful misconduct, or a breach of trust in relation to the performance of the director's functions and duties within the company. And I think in considering, because as I said, it's one thing on paper, it's another thing in real life, and thankfully that's how we have case law. And, I think a practical example of this was, we look at one of the very first cases, which was the Kukama versus Lobelo case. In this matter, Kukama had applied to the court that for the first respondent to then be declared a delinquent director and for his removal on the grounds that Kukama had averred that Lobelo had engaged in reckless trading. He'd used his position as a director, as well as information acquired as a director, to gain personal advantage. And I can go on and on and on as to, what he tried to prove in terms of the act. But the basis of this was that what had happened was SARS had paid out monies to the company based on fictitious invoices that were submitted to SARS. This was in the amount of 39 million. And the bottom line, basically the grounds upon which, they premised this application was that Lobelo's failure to detect the fraud of the 39 million, and then the failure thereafter to then pay the monies back to SARS once it had been determined, was basically found to amount to willful misconduct and or a breach of trust as envisaged in terms of the section. And the court in that instance felt that Lobelo's conduct had fell short of the standard expected of a director of the company to such an extent that it amounts to willful misconduct, breach of trust, and basically a gross abuse of position as a director. And I think in more recent example, we've got Ms. Nyeni of SAA, where the court did not take lightly to the conduct that was presented before it. And where it was alleged that she unjustifiably caused for the demise of a lucrative deal between SAA and Emirates, and amongst other deals. Just in considering SAA's position and her obligation as a director to act in the best interest of the company, the court did not take lightly to the fact that, found that she acted neither in the best interest of the company, and her conduct was neither indicative of reasonable care and skill. And so there are tests, and I'll talk about that later, but it's just determining that sort of conduct.
You've mentioned the Didu Myeni case, and it was very significant in the context of BRPs, the industry, and the media attention that Business Rescue has received over the last 2 years. Can her actions be seen as the benchmark against which future sort of cases of delinquency is going to be used to declare a future directors delinquent?
So, I wouldn't say it's the benchmark, purely because we've had this Kukama case previously, which kind of was the first case that kind of set the tone, set the scene. And then we've also actually had, which the Myeni case referred to, which is the Gehwala case. And in that case, it actually spoke to, what are the circumstances upon which you can bring such an order. And in that case, in the Gehwala case, it spoke about establishing the circumstances surrounding which such an order would be viable. And the court in that instance stated that you had to consider whether the conduct constituted serious misconduct. And in considering what serious misconduct would entail, the court went on to state that it involved a person who grossly abuses his or her position of directorship. And it's equivalent to recklessness. It was confirmed that recklessness and gross negligence involve a complete obtuseness of mind, or total failure to take care, and an entire failure to give any consideration to the consequences of one's actions, whether both foreseen and unforeseen. And so I think in that instance, I think that was sort of the benchmark in terms of, from a practical perspective, or, it kind of gave us an objective in a very subjective test as to what the threshold is. But I definitely do think that this Myeni case is important in that we don't see very many of these these applications made to declare a director delinquent. And I think this has just been a very, very good reminder that companies and interested parties do have this mechanism at their disposal, that it's very important that, that directors are aware of their obligations towards a company, and that they take the necessary care as expected by or from a reasonable professional person. Mnyeni was found to have completely betrayed the trust placed in her as a director. She professed herself to be an expert on corporate governance, which I think, then the court, didn't take very lightly, and said, you've portrayed to have this level of care and this level of expertise, yet you've acted in such a manner. So the court does, take all of that into consideration. And so whilst I don't know if it's quite the benchmark, definitely in the modern era, I think it's woken us all up to those sort of circumstances and the threshold that needs to be met if one is to bring such an application.
Yeah, I think that the role of directors is very important. I mean, even the Independent Board of Directors of Southern Africa wrote to the Zondo Commission of Inquiry recently saying or pointing out the role that directors play in building a strong South African company, and urging the Zondo Commission to talk to other branches of sort of government and legal government to put in more stringent legal sort of steps, such as King 4 and accepting other things in order to strengthen the profession. So Mnyeni was declared a delinquent director for life. What does that mean? And I mean, it leads into my next question.
Okay, so yes, as I mentioned previously, the courts kind of have this discretion as to whether, or based on a case-by-case basis, how long the sanction will subsist. So as I mentioned, the minimum sanction to be imposed should an order be granted to declare a director delinquent. That is for a 7-year sanction, 7-year period. But in Mnyeni's case, we saw the court, as I mentioned, the court did not take lightly to the evidence for it, and it actually declared Mnyeni a delinquent director for life. And so what this means is that she is basically disqualified, and she's not eligible to serve as a director of a company for the duration of her life. And whilst she may apply to court to have the sanction lifted or relaxed, she may only do so after 3 years. And even so, given the severity of the lifetime sanction, I do think it would be very, very difficult for her to get that relaxed. But even so, I mean, she would have to prove, the circumstances upon which she brings such an application and whether it's warranted. And even so, even if the court does entertain such a thing, the court more often than not places a director that has been deemed a delinquent under probation. And so there are many hurdles still to go through. But yeah, that in effect is the consequence of that order.
Now, while she was the director at SAA, she was a director of a number of other companies at the same time. Does the delinquency order from the SAA case apply to all the other companies that she is the director of? Or is it a case of, well, you'd have to prove that she was delinquent in each and every one of those other companies as well?
No, so I think this is why the threshold and the burden of proof in this instance is so high, because the declaration of declaring a director delinquent has way more far-reaching effects than that of an order removing a director from a board of directors of a company. So this declaration or this sanction, it spans over and it disqualifies a person from then acting as a director on any board of any company. And even in the instance where, maybe a board of directors is none the wiser, and a person who has then been declared a delinquent or a delinquent director, then, accepts an offer to serve as a director or acts in a capacity as a director or prescribed officer, an interested person or, a person in terms of the act can then bring an application, once again declaring the person a delinquent director because they are disqualified from acting in such an office. And as I said, I think for repeat offenders, the court may impose then a more severe sanction in terms of time frames and timelines. but yeah, it applies then across the board.
In the interest of wrapping up, Jessica, maybe let's focus on if a BRP has got a situation where there has been mismanagement at a company and they have to, as a last resort, consider declaring the director delinquent because they're digging in their heels and they don't want to leave. What are the important legal aspects that BRPs need to remember when approaching legal counsel to get such an order put in place?
So yeah, it's interesting. I mean, we haven't come across many cases where, if any, I mean, I personally haven't ever seen where a business rescue practitioner has brought an order to declare a director delinquent. You know, they'll normally go the route of applying for the removal of a director in terms of the act. But yeah, for purposes of this discussion, I think with the Myeni case, bringing it to light, we may see more and more going forward. And I think if a BRP was to consider bringing such an application, I think it would be important for the BRP to firstly consider and determine locus standi. I think, it's provided for in the Act. And then secondly, to ensure that, the circumstances that you allege or the misconduct that you allege, that you have enough evidence and enough proof to meet that burden of proof, to show willful and gross misconduct, to show recklessness, and to show, a flagrant or, disregard of a director's duties and the duties imposed on them in terms of the Act. And so, yeah, I mean, in terms of section 1622, it provides, for the people who can bring such an application. And then it goes hand in hand with section 1375, which then talks about, business rescue practitioners' right to bring an application for the removal of a director. And then within that section, the subsection 6, states that over and above the subsection 5, the business rescue practitioner, any right of a person to apply to court for an order contemplated in section 162 is also then afforded to a business rescue practitioner. And so, yeah, I think the most important thing is just gathering sufficient evidence, ensuring that you have a proper case to meet the high threshold, the burden of proof that's expected. And I think it would then be for the court to determine whether you've met those circumstances.